A significant decision was handed down in a High Court case recently that has notable implications for SMSF estate planning strategies. The case was Hill versus Zuda, and Natasha Panagis from Tax and Super Australia is here to discuss it with me. Welcome, Natasha.
Hi, Darren. Thanks for having me on the show.
It's my pleasure. And why don't we begin with a quick summary of what the case was about?
Sure. As you said, Darren, it was quite an important case, and many of us in the industry were eagerly awaiting the decision for some time. Effectively, what the High Court determined was that binding death benefit nominations in self-managed super funds don't need to comply with the super regulations and therefore can last indefinitely. So when I say the SIS regulations, what I'm referring to is Regulation 6.17a, because it's this regulation that provides all of the conditions that must be satisfied for a binding nomination to be valid. And so what this case confirmed is that this regulation doesn't apply to binding nominations prepared for SMSFs. So it means that the requirements such as lapsing after 3 years and having 2 independent witnesses don't apply to binding nominations in SMSFs, unless it's, of course, imposed by the trustee. But just as a real quick overview, if we have a look at the facts of the case, there was an SMSF known as the Holly Super Fund, and it had a corporate trustee called Zuda Proprietary Limited. And the members of the fund were Mr. Sodhi, and he had his de facto partner, Miss Murray, as a member as well. Now, Mr. Sodhi, he had a child from a previous relationship called Miss Hill, but she wasn't a member of the fund. About 11 years after the SMSF was established, the deed had been amended to insert a binding death benefit clause, and it provided that if either member of the fund died, that the trustee was required to distribute that member's balance to the surviving member. So Mr. Sodhi died in November 16, which was more than 3 years after making that binding nomination in favour of Miss Murray. So it's also important to note that Miss Murray was the executrix of his deceased estate. So Miss Hill, the daughter, she commenced a proceeding in the Supreme Court of WA, and she argued that the binding nomination clause from the amending deed was not valid and did not comply with the standards prescribed by Reg 617A. Effectively, she argued 2 things. It failed to comply with the fact that it was signed more than 3 years prior to his death, and also that it was not signed by 2 witnesses. So she relied on the fact that this regulation applied to SMSFs, and therefore any binding nomination had to comply with the requirements of that regulation. So in the end, she really wanted the super monies to be paid to the estate, of which she was the beneficiary.
On the basis of that, I'm assuming that SMSF trustees and their advisors everywhere are breathing a huge sigh of relief, because it means that the administrative burden of having to review BDBNs on a 3-year basis is now no longer necessary.
That's right, Darren. That's what this case confirms. It confirms that because of regulation doesn't apply to all regulated super funds, including SMSFs, that this regulation will not automatically apply to SMSFs, unless, of course, the trustee brings in that regulation and makes it apply to the fund.
Now, you've mentioned the trustee a couple of times. What role does it play whereby the fund might still be bound by that regulation that you're referring to?
Well, if the fund is bound by Regulation 617A, well, then that would mean that the fund would have, well, the binding nomination would have to meet all of those requirements prescribed by that regulation. And these are all of the things such as making sure that the beneficiary is either the legal personal representative or a cis dependent of the member. The proportion of the benefit is readily ascertainable. You know, it's in writing, it's signed. There are 2 witnesses to sign that. It's within 3 years of the nomination. So all of those things, if the deed makes reference to that regulation, then all of those normal requirements within that regulation apply to an SMSF. So if you've got clients with SMSFs that brings in that regulation to apply to the fund, then it might be worthwhile seeking some advice to either update the deed to make sure that that regulation does not apply to the fund, and therefore give them that flexibility to have a binding nomination that is a little more tailored and that can last indefinitely if that is the right thing for the fund and for the members of the fund.
So in that context, this decision should probably be seen as a reminder for trustees to check the details of their trust deed with regard to any sort of death benefit instructions.
Yeah, definitely. Although this court case held that the requirements don't automatically apply to SMSFs and they don't need to be remade every 3 years, it should still be reviewed regularly, particularly when significant events take place in relation to members of the fund who made that nomination. So, your typical events such as births, deaths, marriages, divorce, relationship breakdowns, all of those things. So whenever one of those key significant life events happens, the first thing would be to check the deed and the binding nomination. If the nomination states that it only lasts for 3 years or it is in any way ambiguous, then the member might need a new binding nomination. And so they might wish to have their trust deed reviewed to ensure that the deed provides for non-lapsing binding nominations and that the deed is valid and therefore reflects their wishes and their circumstances. So this is where obtaining some legal advice about implementing a detailed deed can help clarify whether a range of things, such as whether a binding nomination will be provided to a trustee, because this could minimise any disputes whether or not a binding nomination was given to the trustee at the time of the member's death. So we can avoid that scenario.
On a similar note, while the decision has determined binding death benefit nominations for SMSFs don't expire after a 3-year period, it doesn't mean that those arrangements shouldn't be reviewed regularly, does it?
No, it doesn't. So it's always important to make sure it is up to date. It reflects the member's wishes. It's valid. It meets all of those key requirements, because at the end of the day, you don't want it to go to the courts and have the death benefit eaten up by court and legal fees. So it's really important to make sure that although, your nominations can be non-lapsing and can last indefinitely, it's still important to check in and make sure that they remain relevant in the ongoing future.
Okay, well, thanks for sharing your analysis of Hill versus Zuda with us today. That was great.
Thanks, Darren. Thanks for having me on the show.